So, remedy. Remedy is one of the single toughest things in sport. Well, what's that mean, remedy? Okay, so 2 years ago, I picked up a document called Bidding Requirements, and it used words like remedy and grievance mechanism and UN guiding principles. And when it talked about remedy, it talked about Principle 31, and it talked about effectiveness and criteria. And I had no idea what any of this was. And I know if Rachel and Minky are laughing, it's because their fingerprints were on that stuff that I didn't understand. And so we're going to start off today with a little bit of just plain spoken, what are we talking about when we talk about remedy? And why is remedy's hard, period? It's pillar 3 of the UN guiding principles. But in sport, it has its own particular challenges that are unique to sport. Why is that? What are the challenges? And how are we making progress? But then also, what needs to change? What do we need to change to really bring meaningful remedy, once we figure out what that means, to sport and to those affected by it? Now, we're going to toughen up a little bit because we're on the remedy panel. We have a big panel, and we got started off 7 minutes late. So I now have my red and my yellow card as the moderator, and we now have the FIFA signboard. So Minky, if you go over, we're absolutely going to bust you on it. So I'd like to first bring up Rachel Davis, who I have a tremendous amount of respect for. There's no finer person to help us navigate some of the basic elements of remedy and grievance. Rachel, please.
Thank you. The respect is mutual. And it's a pleasure to be here with all of you who have worked very hard on this area and are continuing to do so. And there are plenty of stories, individual stories in the room today about situations of either where remedy has been obtained or where people are fighting extremely hard for it. And I hope that's something that will come out in the discussion with the audience after we all finish talking at you. But I have been asked to start by laying the table for the conversation because exactly as Mary said, when we talk about remedy, it immediately gets just a bit uncomfortable. Right? This can be a very emotional conversation. It can be an awkward conversation. It's obviously emotional for people who have experienced harm, who are trying to tell their stories, who are seeking remedy. But it can also be emotional for those of us inside sports bodies or in governments or outside in the organisations, civil society and trade unions who are trying to help them, to support them, to address their case. So we know that this is difficult territory. And we also know that it's a lot more comfortable to talk about prevention. And we need to talk about prevention. But if we can't have honest conversations amongst all the stakeholders who are in this room, who are at least united by wanting to see sport and human rights come together, if we can't find a way for having those conversations, then when negative impacts happen, and they will happen, because the world is complicated and things go wrong, then we won't be able to address them with the professionalism and with the care that people who are affected, complainants, victims, survivors, that they deserve from us all. So that's why we are investing this amount of time in a difficult conversation. I've spent 6 years working on the UN guiding principles, developing them, and now 8 years putting them into practice with a wide range of organisations. And in that time, I think the most insightful comment that I heard about remedy, about grievance mechanisms, and I'm going to talk about what those mean, was from the head of stakeholder relations for an extractive company in Latin America. And she said that when she started in her job, she was terrified of complaints. She got them all the time from all directions, from community members, from workers, and she thought every time I get a complaint, it's a failure. I failed. Right? I haven't done something, there's going to be liability, the top management is going to be really upset, and it's all on me. And she said the moment that she was able to really transform her job, her role, her understanding of what she could do was when she realised, and bear with me because I know this may be sounds like a lot to stomach, but this was her words, that every complaint is a gift. That's an extraordinary thing to say, right? But when she realized that it was, she said, I was able to see that every time someone was brave enough or courageous enough to come forward with their complaint, they were giving me direct insight into risks to them, into what they were experiencing, but they were also giving me insight into risks to my company, my organisation, to the brand, to the integrity of what we do. And so I realised that actually what they were giving me was a gift and that I should treat it that way. And I think I would ask all of you for this discussion that we're about to have, which may be awkward, it may be emotional, it may be difficult, but please just to come to it with that mindset, because I think that can transform how we think about remedy and how we think about the people who are in need of remedy. I want to do three things. Define remedy. I keep using the word. What does it actually mean? I want to also talk about grievance mechanisms. Again, this is another term we tend to throw around a lot in the business and human rights and sport and human rights space. So we'll talk about what that is. And then I want to touch briefly on what we think the history of the UN Guiding Principles and the experience of the private sector can offer this evolving conversation in the world of sport. My apologies to the interpreters. I'm talking too fast and too much like an Australian. I hope everyone can understand. My apologies, I will try to slow down. So, first of all, what is remedy? So I'm a lawyer by training. Yes, I have outed myself, I am. That means I learnt a very particular meaning of remedy. Cases, parties, dispute, litigation, liability. That is very important, and we'll hear from Greg that certainly legal cases, legal actions can be a very important part of remedy. But I want us to not go straight to that idea of liability and take a step back and think about what we mean by remedy. And the way that remedy is defined in the guiding principles and in the work that we're all doing on human rights is by making good a harm, right? Putting someone back in the position they were in before a harm occurred, or as close to that as we can manage, because sometimes that's not going to be possible, or it will be very challenging. But that's the goal, right? To put them back in the position they were in before the harm. And there are different ways in which we could do that. We can think about 5 of them, just to get started. The first, and I encourage everybody not to underestimate this, is an apology. Sounds simple. It's not always easy to give one. It's not easy to get a large, complicated institution to give an apology, but it can be extremely meaningful to someone who's been harmed. Second type of remedy is financial or non-financial compensation. Still too fast? No. Okay. I was watching the signals. Financial or non-financial compensation. And again, in some cases, financial compensation, it's an obvious remedy. It's clearly what we need to do. In other cases, the scale of the harm, you've been abused, you lose your entire career, you are displaced for a tournament, you've lost your house, your livelihood. Financial compensation alone is not going to be a total picture of remedy. So what else might we be able to think about? Another form of remedy is restitution, and that's just a way of saying giving back to something, giving back to someone what was rightfully theirs. And that could be someone, for example, who's excluded from a job or from a position on a team because of their trade union membership. The right thing to do is to give them back that position, what they were entitled to in the first place. A fourth form of remedy can be sanctions. Now, we know that only the state can provide criminal sanctions, but organisations, sports bodies can impose penalties, they can impose fines, we see them doing that. So that's a very important form of remedy as well. The final type I would encourage everyone to think about is prevention of future harm. And why is that a form of remedy? Well, if you've had the confidence to come forward and share what has happened to you and seek remedy, one of the things that might keep you going, and we hear this firsthand from people who have been in this position, is the fact that I can prevent this happening to someone else. That is a very important motivation, and it's something that we can respect in how we develop remedy in response to their claim. I want to move to what we mean by grievance mechanisms, and I would like to ask you all a question. How many people in this room have filed a complaint or lodged a formal complaint of some kind? It doesn't have to be about a human rights issue, just something that affected you. Up high. Okay. How many people, keep your hands up. How many people keep your hand up if you were satisfied with the process? Yeah. And the outcome? Oh, they went down. We have one. Excellent. How many people have experienced some kind of harm, again, not necessarily rising to the level of a human rights harm, and didn't file a complaint? Yeah. And that's, I think, both sides of the problem that we're trying to address, right? And sport is not alone in trying to address this problem. We file a complaint, it's a really hard process, we don't like it, we don't get a sense that we're respected, we don't feel we get a proper remedy, or we don't even file a complaint in the first place because we have no confidence that something will come out of that system, of that process. So this is why grievance mechanisms are such an important part of this discussion, because it's through a grievance mechanism that we can often access remedy, that we have a chance of accessing remedy. So how we structure grievance mechanisms, which really just means a process for bringing complaints into an organisation, evaluating those, and then working out who needs to deal with them, how they're going to get addressed inside the organisation or outside the organisation, is extremely important in achieving remedy. Grievance mechanisms are about solving problems as close to the point of impact as possible. So preventing issues before they escalate. And there's a business case there that has certainly resonated for companies in the private sector, and I think in principle should be the same for sports bodies as well. We don't want things to get worse. We don't want them to get worse for people, and we don't want them to get worse for us as organisations. I'm really struck, though, when we look around at the world of existing sports body mechanisms and we look at what they were designed for. Now, most of them are designed, and this is understandable, to address disputes between a sport body and an individual official, right? They're designed to protect the integrity of the game. They're not designed to protect people who are the heart of the game, or people who are connected to the game, people in and around tournaments. So when we think about how we go from a situation of people not filing complaints or not liking the process they go through or not feeling that they get remedy at the other end, we've got to think about whether we are adjusting existing mechanisms or adding new mechanisms, or looking, and this is what the UN Guiding Principles have to offer, at how we develop more of an ecosystem way of thinking about remedies. So looking at state mechanisms that we could build on, looking at what can be done within sports bodies, and then looking at how sports bodies can tier their responses up from the local to the national to the international level. So there's quite a lot of work involved in that. It's not an easy process, but it is a process that the private sector has been working on for over 10 years now. So again, my fundamental point is that sport is not alone in dealing with the challenge of remedy, the need for effective grievance mechanisms, and the attitude shift that recognises that a complaint is actually a gift and that we should treat it accordingly. Thanks.
Okay, I am going to slow down. We do not want our interpreters quitting on us. So Rachel brought up a really interesting point, right? So if you come from sport and you look at how complaints are handled, they're handled and designed to handle complaints that aren't necessarily contemplated human rights. I'll give you an example. You're a fan, and you can't get into a stadium because you're female. Who do you complain to? You're an athlete, and you have been harassed, abused in the worst way, and you go to complain, but your abuser is part of the actual sport infrastructure itself. They're part of the actual sports body that has the grievance mechanism that you're supposed to use. What do you do then? Right? So, and if you look at the grievance mechanisms that are there, they're built to handle very different things. They're not built to handle these things, right? What nationality of national team do you play for? Is your doping status upheld or not? Are you sanctioned because maybe you cheated or there was some issue with how you were elected or something like this? These are not human rights challenges, right? But these are the mechanisms that are being used in sport to look at human rights. So I'd now like to turn over to Minky Worden of Human Rights Watch. And this is going to be a little bit sobering, so let's keep it upbeat, if possible, on what some of those challenges are. Because we need to know what we're talking about in order to understand how to fix it. Minky.
Thank you, Mary. Thank you, Rachel. I'm Minky Worden from Human Rights Watch, and I think for some people, I may be the scariest person in the room. So I want to say that I'm not scary at all, but I want to begin with some practical advice, especially for sports bodies, for governments, for everyone. And that is that all governments commit human rights abuses. All sports federations are complicit in or participate in human rights abuses. And if you are in sport, you're often going to experience a human rights abuse, deal with, or have to confront the fallout of a human rights abuse. And what I've seen change in the 21 years I've worked on these problems at Human Rights Watch is that we have a new set of tools, we have a new framework, and we have a community that is committed to addressing human rights abuses in sport. And that's a very fundamental change. As Rachel and Mary have said, the UN Guiding Principles give you the tools, but also the relationships to assess risk. So risk is the main thing that you should know if you're involved in a sports event, if you're an athlete, if you are a sports federation, you need to know what the risk is. You need to manage abuses when they happen, and I've just told you they will happen. And above all, when you find out that abuses have happened, and we're happy to tell you when that's the case, you need to take steps to do the right thing for the people, the families, the athletes, and the fans who are affected. And I want to speak especially to the sports federations in the room who are new to this process. And I want to thank you, because being in the room is the beginning of the solution. And as our corporate partners said in the last panel before lunch, the more people there are working on this, the safer it is. The more people in the water, the safer it is for everyone to swim. The work that Human Rights Watch does in the sport ecosystem is to document human rights abuses in sport or caused by or associated with major events like the Olympics or the World Cup. And I want to tell you what some of those abuses are. They are pretty much in the order that they happen: forced evictions without compensation. And when you hear that, you should actually think of families being bulldozed from the homes that they've built. They are migrant workers who are dying entirely preventable deaths on construction sites, not just stadiums, but hotels, infrastructure. It's the arrest of environmentalists or journalists, crushing of civil society actors who may document these abuses. It's slavery in supply chains. It can be the closing down of the internet. Women and teenage football players who are sexually assaulted by sport federation leaders or other athletes. and laws against exclusion and violence against women, LGBT people, and fans. I wanted to give some specific examples of where we've seen this happen and what steps federations took to address it. And I wanted to start with the Sochi Olympics. In early 2014, Human Rights Watch brought a report to the International Olympic Committee at their headquarters down the lake in Lausanne. And the report was called Race to the Bottom. It documented wage cheating and abuses on all of the major Olympic sites for the Sochi Olympics. And I do have to put myself in the position of the IOC officials on the other side of the table. They were not so happy to get this report, but they accepted it. And what happened after was what was important. The IOC did 500 investigations. And in the end, as the Sochi Olympics were opening, as the fireworks were going off, the IOC made sure that the Russian organizers paid back 6,175 workers $8 million in wages. And that, I think, is, at the time, the IOC really did not have a human rights policy, but it had made a commitment that if these abuses were documented, that the IOC would take steps to remedy. So you can do remedy outside of a human rights framework. You could start to do remedy now, even if you don't have a human rights framework. A second story I wanted to tell is about, you are all familiar with the problem of sexual abuse in sport. USA Gymnastics, we heard last year at the Sporting Chance Forum from Jessica Howard, the third whistleblower in the Larry Nassar catastrophe. And remedy in a chronic situation of sexual abuse is very difficult. I wanted to recognize Kelly Lindsay in the room. Kelly Lindsay? Please stand up. Sexual abuse also happened at the Afghan Football Federation. Kelly Lindsay was the coach who players came to with evidence that the president, Karamuddin Karim, had systematically abused players, including teenagers. She brought the claims to FIFA, and over the last 2 years, she has worked with players and taken their stories to FIFA and to the judicial system. In June, Karamuddin Karim was banned for life and fined $1 million Swiss francs. In this case, Kelly Lindsay was the initial remedy, and she's worked with FIFA to get Karamuddin Karim out of sport. But it's also important to recognize, thank you, Kelly. It's also important to recognize that FIFA did not have a system fit for purpose to address what was a very serious problem, and that actually affects the access of women and girls to sport, right? You can't play a sport if it's unsafe. Your parents won't let you. So I think you find out through these cases where the problems in the system are. So part of remedy is actually looking at the system and assessing where have we failed. It's lessons learned. A third example of a real case I want to give involves the courageous women of Afghanistan who have for 40 years been banned from attending, Iran, from Iran, jet lag. The courageous women of Iran have been banned from football games and other sports, other stadiums. And starting in 2005, they had campaigns. They brought this information to FIFA, but it was only really in the last few years that FIFA started taking steps to remedy the problem. Some of those steps, which have not been made public, include FIFA made it possible for women from Iran to hold signs at the 2018 Russia World Cup. That's a form of remedy. FIFA met with the women of Iran. FIFA, in the end, gave a deadline. The deadline turned out to be the critical remedy that would allow women to sit in the stadiums. So I wanted to say that these are all real-life cases. They're all still ongoing in a way. Remedy also doesn't end with one solution. It is an ongoing thing, and it's part of justice and accountability. And as Rachel said, all of these steps can ultimately lead to prevention, right? Prevention of future sexual abuse, prevention of future worker rights abuse, and prevention of women and girls being excluded from a sport they love. Thank you.
That is excellent, Minky. That gives a pretty good, I think examples are always helpful, right? When you have examples and you realize this is what we're talking about, right? This is why this doesn't work. I'd now like to invite, so we have on the panel 3 different perspectives. So we have Greg Nott, who has represented an athlete named Caster Semenya. And at the center, we've looked at both sides of this in our work. And Greg's going to give a perspective of an athlete and what it means using existing remedy mechanisms in order to, or grievance mechanisms to provide remedy for Caster Semenya in this case. And then we have workers. Jin Suk Lee from Building Woodworkers International, who works with the center quite a bit. We'll look at construction-related risk, and then Andreas Graf from FIFA, who can talk about their work in probably a variety of different areas, but in particular, the work that they've done also in Qatar and in other areas, working alongside Building Woodworkers International and the ILO. So I'd like to start, so we have athletes, workers, so 2 affected groups, if you will, vulnerable groups. And then we have a sports governing body who can provide a narrative around what they're doing and what challenges are also for them in offering remedy. So I'd like to start with Greg. Thank you.
Thanks very much, Mary, and thank you very much for the privileged invitation I've received to share what hopefully is an inspirational story for those of you who are listening, that it resonates and you can identify with what I'm going to share. To you, Rachel, well done on the legal remedy and defining it. Minky, substance, thanks very much. To my co-panelists, welcome as well. The journey of Caster is really one of just not the CAS arbitration and the award that we've seen this year. It's a story that goes back 10 years, which even makes it even more substantial, even more egregious. It's one which really has always got to the very heart of me. Rachel spoke, sorry to the translators, I do speak quickly. Rachel spoke about this being possibly an emotional, awkward, uncomfortable conversation. And I suppose it might be all of those things. Were I not to be representing Caster Semenya, who is an indomitable spirit, who is a strong woman, who, despite all the indignity that she has suffered, the most fundamental human right of who she is and being told who she is to be has been out there. She finds the indignity of it so bad, so outrageous, and yet she focuses on her sport, and that is to run and be a professional. She cites that time and time and time again. The story really begins when I was watching the 2009 Berlin World Championships with my youngest son. I have 3 boys, and we were cheering Caster on, and she went on to win. But the very next day she was suspended, and the award was taken away from her. And I was walking my dog in the local veld, which is the local grass park, and sorry, that's a South Africanism, and I really was outraged by the fact that this actually had happened to Caster. It hit me in the pit of my stomach. Maybe it was a paternal feeling of what this was about. What could we do to help a person coming from the poorest province of our country, the Limpopo province, a young athlete with very little resources? How do we assist? And I telephoned then our human rights founder of human rights in South Africa and said, we've got to do something about this. Anyway, a couple of weeks passed and I met up with Custer and I drove away with my young associate and said, we can do this. Why could we do this? We could do it because of Custer. She showed an indomitable spirit then. She wanted to win 1, 2, 3, 4, 5 medals. And so while she was a victim of a segregated decision, she wasn't a victim in herself, and she remains that. Over the 10 years, there have been many instances where the association and others have attempted to put her off the track, have attempted to stop her in her tracks, but have failed to do so. This story has yet to be told. We then get down to the regulations, which we all know are out there and have been a subject of a court arbitration. How does one get to a remedy of fighting that when you are from the poorest province, notwithstanding that you are an elite athlete? One, resources. I was very fortunate 10 years ago to call upon my law firm and say to them, we need to assist. I was very fortunate enough on this last occasion to have a vast network on which I could call to raise monies, because on this occasion I had to get in Canadian lawyers to assist us in the CAS case. This case has cost well over $1 million, and I must thank Dr. Prashni Mitra sitting over there for her kind assistance in facilitating some of the engagements that we've had. If you may stand as well, I think you would need to be recognized. Prashni is a dedicated human rights activist and a person who's linked us into a number of people who've assisted us in terms of their advice and so on. So this case has over 10 lawyers, over 3 continents, with experts to assist in making it happen. It's quite extraordinary. Where else can you get an athlete to be able to assist unless you have the power to do so and to be able to rely on that power? So it's all very well to talk about remedies, but how do you get to that remedy? I loved what David said earlier from the Commonwealth Foundation about the Soweto threshold. Get there, start to talk the language. Get in terms of people's heads. What are we crafting? What are we drafting? So we're not sitting here just in an afternoon listening to some lecture from some boring lawyer. We need activism. We need to get up and say, we are going to take this forward and we are going to draft and craft something which actually identifies with the athlete, identifies with the nation it comes from. And let me tell you, South Africa takes itself very seriously in regard to sport. And hence, it is such a defining topic for us. We are a country as a project at the moment. It's a democratic project. And people like Custer bind us. They create something for us. It's so important. I'm sorry, I'm going on a bit long. I'm very conscious not to take too much time, Mary. I could go on for a bit longer. But those are the various points in terms of remedy. Make sure that you've got the resources to ensure that you have it. Ensure that there's an overarching acceptance of a constitutional right so that the human dignity is afforded and looked after. And moreover, make sure that the representation that you have before the various bodies is one that is heard and hears the athlete herself or himself. Thank you.
Thank you, Greg. I think the 2 questions, not now, but later, that I'm going to come back to you on, just give you, the first one is why did you take the case to CAS? So were there other options, given the nature of it? And secondly, what's interesting about Custer's case is that she was born this way. This is her natural state. This isn't an altered state. This is not to say that there's anything wrong with other ways that athletes compete, but in this case, particular case, I think what's interesting is that this is her natural state, right? There's been nothing. So I would like if you would comment a little bit, because I think from a human rights standpoint, that's actually pretty defining in certain cases. So I'm going to come back to that, and I'd like to turn now, so Jinsuk and Andreas,
You've worked together quite a bit, and I'd like to know which one of you, do you have a preference of who goes first? Would you like to? Jinsuk, okay. Why don't we go first, and tell us a little bit about the work that BWI has done in remedy.
Hello? Andreas has asked me to go first because he wants to be last and saying, I've heard it all, and now I'm going to change my speech. But I still get to say that because I've heard it all here, too, and I can change my speech. So for some of you who don't know the Building and Woodworkers International, I'm a bit egotistical. I think everybody knows us, but I assume there will be many here who do not know us. And it's actually fitting that I follow somebody from South Africa because our global campaign, sports campaign for decent work and beyond, actually started with the World Cup in South Africa. So, and of course, the focus of our campaign has been to ensure decent work, safety, and health working conditions for construction workers, as well as respect and dignity. So, with that goal in mind, remedy is very important for construction workers. I want to share at least two recent examples that we have been engaged in. One is in Qatar, and of course, one is in Japan. The relationship with FIFA has been a very long and challenging and also fruitful one, I would say. And this played out with our work in Qatar. Qatar was very challenging for us, and because for BWI, we of course believe that it is duty of governments to, of course, to ensure remedy for workers. But we believe that sporting bodies have leverage and responsibility to use that leverage and influence in terms of ensuring remedy and grievance mechanisms for construction workers. And this is how we started our engagement with FIFA. And this is one of the, when Rachel was talking about one of the mechanisms of grievance mechanism system, one of the things that we used actually was our complaint, OECD complaint against FIFA, which was, I would have to credit the Swiss government in accepting the complaint and mediating, and which resulted in FIFA actually accepting its responsibility, and that it had leverage to influence in terms of the conditions of work for construction workers. For us in Qatar, we've believe that there are a lot of mechanisms that are in place, particularly by the Supreme Committee for Delivery and Legacy, to ensure remedy for construction workers. So for, as people were defining what does injury mean for construction workers, what they want remedy is to make sure they get paid on time, make sure that they can go home at the end of the day without a broken limb, alive, and to make sure that they're not, they're respected in dignity. And this is one of the things that we actually pushed for, and we, as a result of our MOU with the Supreme Committee, we actually engaged in joint safety inspections. And part of those joint safety inspections, what was positive is that we're able to audit the safety sites, as well as make specific recommendations to contractors, and then go back and do the inspections again to make sure that the recommendations are in place. So this is what when Rachel was talking about, to make sure that to prevent harm. So for us, the inspections, the joint inspections, is actually a mechanism for us to ensure that there's looking and make sure that remedy is in place, and also preventive measures. And then another important part for us in terms of Qatar is the workers' welfare forums that the Supreme Committee has been able to set up. So we have to really credit the Supreme Committee having set up all of these mechanisms, and we've been able to observe the workers' welfare forums. I mean, we're trade unionists, so for us it's critical that we push for 87 and 98. In a country that does not allow trade unions, the workers will, exactly in a country that does not, again, I repeat, in a country that does not allow trade unions, workers' welfare forums is a mechanism for workers' complaints. We have seen workers being elected, we have workers being representing their co-workers, and we have also seen a transformation in the workers' welfare forums, where the initial discussions around food or accommodation facilities has evolved to looking at issues of recruitment fees, as well as looking at wage issues and transportation time. So all we would eventually like to work with the Supreme Committee, and I see Mahmoud and Pavan there, is to negotiate collective bargaining agreements. So that is what we hope to achieve before the 22 World Cup kicks off. And Mahmoud is laughing, but I believe that that can be achieved. So I use our positive experience in Qatar to contrast our dilemma in Tokyo. And we have been engaging the Tokyo 2020 organizers for a long time in the same manner that we had engaged in Qatar. And one of the arguments we always got from the Japanese Tokyo 20 organizers is that this isn't Qatar. It's true. Japan is not Qatar. Japan has free trade unions. They've had free trade unions since World War II. It's true. Japan has a mechanism to deal with human rights issues. Japan has a long tradition of human rights issues. And this is coming from a Korean, a woman to say Japan has a long tradition of human rights issues. It's not Qatar, but our interaction with Japan is anything positive. It's been very challenging. It's been closed. We have documented cases of workers' violations of safety issues. Workers have complained in what they have defined as their grievance mechanism systems, but they've thrown out all of the cases as saying it's unjustified. They've thrown out the complaints that we have said, and they have not even contemplated looking at alternative ways to find solutions. We've offered joint audits. We've offered interviews with workers. They've said that this is not what they would only stick with their grievance mechanism system. So the contrast in Japan and Qatar is really diverse. And so for us, I'm concerned about this woman raising her card, so I will quickly finish. So for us, because of what's happening in Tokyo, since we're not getting anywhere, we're now looking at the IOC. And this is what, the whole importance of where sporting bodies are coming in. If we can't get anywhere with the local sporting body, then the IOC, which is the supreme authority of the Olympic Games, has to step in the same way that we expected FIFA to step in. And I'm sitting in the same panel with Andreas, side by side. I have to give credit to FIFA. They did step in, and we have a working relationship. Yeah, you did step in. And this is what we would like to see with the IOC, that they have to step in, and when their local organizing committees are inactive and not pushing on ensuring that there's remedy and grievance mechanism systems for affected workers. So I'll end here.
Thank you, Jin-Suk. So a lot of things in that. I'd like to immediately go, though, to Andreas. And Andreas, Jin-Suk certainly has given quite a bit, but also between Minky as well, mentioned different cases. I'll let you address all of them, whatever you'd like to cover. So from FIFA's side now, the sports body response.
Thank you very much. Thanks for the invitation to be in this panel. I'll be happy to talk about all those cases, probably in the question and answer session or in the discussion later on. Well, let me first say, any conversation about remedy, and we have heard it very much, is really a conversation about individuals who are affected by activities, in our case, by activities in sport. So this is really the part of my work that brings me in closest contact and makes me work most closely with the individuals who are affected by our activities or by others who are linked to our activities. So I just say there are a whole number of people here in the room with whom I had the privilege to work with over the year. For many of them, it was not sure whether at the end of the year they will be able to come here, will be safe enough to come here. And it's a pleasure to see all of you here. And well, I think as a Swiss citizen, I can say welcome to Switzerland. In terms of an introduction or an overview to our work. I think it may be helpful now after the conversations in the morning and now also the initial panel to see a little bit where we come from with our human rights work more broadly, and then also what that means in terms of remedy. Because I don't think we have a blank sheet in front of us. We have a lot in front of us to work with, to work on, to expand on. So, as most of you know, FIFA is committed to respecting human rights in February 2016 with the integration of an article in its statutes. And we've since then been working to implement that responsibility throughout the activities of the organization. Now, I myself joined FIFA a little bit after that in a new position that was created at the time for a human rights manager to help the organization exactly implement that commitment. So in many ways, I think it's fair to say we went by the book. We integrated regulations in the statutes. We developed a human rights policy. We identified the most salient human rights risks we are facing as an organization and started to strengthen the due diligence processes we have around those issues. So just a couple of examples, for instance. So we introduced, and we have heard that before, we introduced requirements in the bidding, selection, and the hosting of our tournaments since November 2017. We've stepped up our efforts with respect to Russia and then also Qatar through a wide range of measures around labor rights, around anti-discrimination, around the protection of human rights defenders, fundamental freedoms. We started to work quite closely with member associations around key salient issues that happen at the member associations level, speaking in particular about child safeguarding, but also anti-discrimination and other areas where member associations are key in addressing the risks that are associated to us. And then last but not least, we have worked a lot to forge good relationships and trusted relationships with many of you here in the room who have the role to have a critical eye on what we do. Some of them sit here on the panel, and others are out there in the room. Of course, that has been a critical component of our work, and it has made it critically better over the years. Now, a lot of that work has been focused on prevention of harm, and I think rightly so. So if we work or if we kickstart trainings for Qatari security personnel around human rights compliant policing, it is because we see that there may be a challenge coming in that area. If we engage with the Russian authorities around fundamental freedoms and protection of human rights defenders before the World Cup, it was because we were aware that issues may come up and we wanted to prevent them from happening. If the Supreme Committee, and I really do not want to take too much credit for the work of the Supreme Committee, which is wonderful in its own rights, and we've heard it from Jin Suk around the labor rights on the stadium construction sites. If the Supreme Committee implements all those mechanisms on their sites, it is because they want to prevent harm from happening in the first place. But equally as important is to be able to do the right thing when things go wrong. And as Rachel said, things will go wrong for an organization as big as ours with a reach that is as big as the one of our organization. So fundamentally, it is about how we do react when things go wrong. How can we make right if things go wrong? Either we may have contributed to that wrong ourselves, which makes it easier to rectify it, or other people may be harmed by third parties associated with our activities, and still we think we have a responsibility to work with others and to promote access to remedy for those individuals. So if we take a broader look at the work that we are doing around remedy, some of those activities are mechanisms that we put in place ourselves. Others is work that we work with third parties that they put in place their mechanisms to be as close as possible to where things happen. And then there are also areas where we can rely on state-based mechanisms and forge a relationship with them for cases to be dealt with by those mechanisms. I think there are three areas of that work in line with the key salient human rights issues that we are having as an organization. There are a number of grievance mechanisms of relevance for the tournaments. If we think back at Russia, we had launched that human rights defenders journalism complaints mechanism before the tournament because we felt that was an important thing to do, that we are aware when things would happen to human rights activists or journalists linked to the tournament. We've now piloted a event time safeguarding mechanism at the FIFA World Cup in France and are taking the learnings from that through to future projects around event time safeguarding. In Qatar, we've spoken about what has been done on workers' rights. There's an additional piece of work that we have been doing over the past months to exactly look at what are the available avenues for remedy that people have who may be affected based on the human rights risk assessment we did for the tournament. And based on that, we're now either developing our own mechanisms, for example, around spectators and communities, or seeing how we can work with others where effective remedy mechanisms are already there for other areas. If we look at the second cluster, linked to FIFA's role in football governance, again, there are a number of mechanisms that are there that should be looked at. There's obviously around the players' rights question, the FIFA dispute resolution mechanisms that are there, that have been there for quite some time. Most of those cases do have a human rights component to them. There's the FIFA ethics regime, which essentially is there to investigate and sanction football officials for any sort of unethical behavior. So we hear about that terrible case in Afghanistan. That's the mechanism through which the president and then eventually also the Secretary General has been sanctioned by FIFA and banned from football. Then there is the work we're doing around child safeguarding with member associations, where we work with member associations to make sure that they connect with the national child rights protection systems that are there, because we cannot expect member associations to put in place mechanisms that are fit for purpose for these kinds of sensitive issues, and where there are other mechanisms available, it's critically important that we link to those mechanisms. And then there's also the disciplinary procedures around things that happen in a stadium during a match, and discrimination is one of the areas where member associations get regularly sanctioned as well, and where we then work also with member associations for them to implement action plans around that topic. And then the last cluster, a brief one, as any large organization, we have our grievance mechanisms for our FIFA staff, questions around workplace bullying, workplace sexual harassment, and I guess most of you have the same in your organizations. All of that to lay that on the table, because that's, I think, when we talk about FIFA, that's from where we start the discussion from. Needless to say that a lot of this is work in progress in terms of building on existing mechanisms, make them fit for purpose to address some of the most egregious human rights harms that we can think of in some of the most difficult contexts in the world. Work in progress in terms of building new mechanisms where there are still gaps. And then also work in progress in strengthening the relationships we are having with human rights defenders, with individuals who may be affected, to make sure that the mechanisms we do have in place meet the needs and the requirements that they are having. And then happy to address any particular case that has been raised over the day or will be raised in the discussion. Thanks.
Thank you, Andreas. Okay, so we are going to do not speaking quickly, but speaking succinctly. We're going to do a rapid round because I want to make sure that the audience has an opportunity to ask questions. So I'm going to do some fairly targeted questions, sort of quick question, quick response on a couple of things. So my first one is for Rachel Davis. You were also the chair of the FIFA Human Rights Advisory Board, so you have a couple of hats. All right, so one is you've had a front row seat to a lot of the challenges that FIFA has navigated through. And this is a lot about football and a lot about FIFA, okay, and I get that. And this may or may not resonate for many of you here, but I think the process, if we peel away, construction-related risk and a lot of other things, and just think about the process for a minute, I think we'll find common ground. So from the Human Rights Advisory Board, your thoughts on it and what have the challenges been, very quickly. And secondly, I'd like you to comment on grievance mechanisms being fit for purpose when it comes to talking about things that are not necessarily the things that these grievance mechanisms were built for.
Okay, to be succinct, I'm going to answer both your questions in one. And I'm going to talk about it in connection with FIFA because, as Mary says, one of the hats I wear is chair of the pro bono Independent Human Rights Advisory Board to FIFA. I've had that role for 3 years now. And I think just focusing on the last year of the advisory board's work and where we've seen progress and challenges in what FIFA is doing, and Andreas has described a wide range of things that FIFA is doing. I think we can see already an evolution in the role that we are playing even between the start of this year. We heard earlier, Craig mentioned the case, incredibly critical case involving Hakeem Al Araibi, who of course is here with us. And in that case, the advisory board came in with some very specific recommendations to FIFA, steps to take to try to secure a remedy. FIFA was acting already, FIFA continued to act, others were, and we eventually had a successful outcome. In cases subsequent to that this year, we haven't felt it necessary to make those kinds of specific recommendations. We see that the processes are working more, I think, inside the House. And so what we have been focusing our attention on is the systems themselves, and particularly the existing structures, so the ethics system and others. When you start to try to fit severe human rights cases or cases of severe human rights abuse into systems that were not originally built for that. That's not the fault of the system, it's just a fact. So we need to think very carefully about how best to respond to that. I think we see really positive developments in the work that FIFPro, who are standing out the back, and I'm calling them out, so it's a bad time to be talking, Jonas, that they've been doing with the National Dispute Resolution Chambers, which are important for addressing footballers' rights and athlete rights in that context. One of the key features of that system is that the complainant gets to choose, gets to be part of choosing who the arbitrators will be. And I want to emphasize that point because as we think about redesigning sport remedy systems, at the heart of that, again, should be the users of those systems. And the more we can give those users agency, choice, information early, a real range of options, and the ability to feel that they have some control in what can feel like a very long and drawn out and confusing process to go through, then I think that's the direction we need to move in.
Terrific. So affected groups are critical in finding solutions. We talked about that this morning. I love the example that Carl Eric gave about his players meeting with Amnesty. Tough customers. If you meet with Amnesty, you better fasten your seatbelt, but they're going to tell you what you need to know. And so, you know, this theme of stakeholders being engaged in the process, Jin Suk and perhaps Andreas, I'm going to come back also to Minky, and then we're going to get to your questions about CAS, is the role of, what I think was really interesting, Jin Suk, what you mentioned is that the independent inspections are basically taking representatives of the workers and independently verifying whether or not their health and safety is being taken care of. Can you talk about why that aspect of it is so critical? Because that's not something that's done often.
I should clarify. I mean, the inspections that we do in Qatar is actually joint inspections with the Supreme Committee and our inspectors. So these are inspectors, safety inspectors of BWI affiliates. And you're clearly right. This is very rare. So because each company has, construction company have their own inspectors. The Supreme Committee obviously does their own inspections regularly. But our joint inspections is to verify independently and to confirm that the procedures are in place and to make sure that if procedures are not in place, then what are some recommendations that we can make? And they can make the changes. I mean, I think this is okay to say, Mahmoud, because I mean it's been released in the reports. I mean, the earliest inspections that we did, the first inspection that we did, we found that there was a problem with maintenance of the harness systems, And so as a result of that inspection, and harnesses, harnesses which the workers use and height, and harnesses are important because if you don't have a good harness system, it leads to fatalities by falling from height. And so we were able to work. It was one of the things that came out of the inspections, and it was a procedure that the SC put together in all its sites to make sure that there was a review of the harness systems. So this is why this independent safety inspections are critical, because it saves lives. And this is what we proposed to the Tokyo 2020 organizers, and this is something that they refused.
Okay, so stakeholders being key in finding solutions that lead to prevention. So Andreas and then Minky come in on, I mean, you're both sides, right? So you're the sports body that engages stakeholders, and Minky's the stakeholder. Talk a little bit about how that dynamic has been easy, right? It's been a challenge over time. So can you talk a little bit about what it's been like? Because this is scary, right? You're actually engaging with someone who's going to flat out tell you in no uncertain terms, you have a problem and here's what it is. So that's brave to do that, but just talk a little bit about what that's been like.
Well, I think the relationship has certainly improved over the years as we have grown more confident about the work that we are doing, and as also, I guess, Human Rights Watch and Minky have been more confident in acknowledging that we have been part of the solution in enough cases that they can expect us to also be part of the solution in the case that will come up in that moment. For us, engaging with people like Minky, but frankly many others here in the room, is fundamental to understand where we have a problem in the first place. And that gets a bit to what Rachel has said before. As an organization, the reach of our activities is so large. We can put in place a lot of mechanisms and try to find out where issues are. But there are so many ears and eyes out there, and probably thankfully enough, it's also something that is attractive for organizations because they get attention internationally by doing that when they do it in relation to us. We learn a lot about challenges that are out there through our relationships with stakeholders. So that's key number one. Second, of course, once we have that trusted relationship, and PWI is a very good example. Human Rights Watch is another example. We can actually work together to address particular cases. We have had in previous Sporting Chance Forum, I think, Semyon Simonov here in Russia, who faced issues when he did research for Human Rights Watch on a stadium construction site. I mean, that was for me a very early and a very telling case in how, by working together with an organization such as Human Rights Watch, we can actually get good outcomes for both, and in particular also then for the individual who has been affected.
Terrific. Minky?
Well, I wanted to say that I knew that things had changed at FIFA when Human Rights Watch, our researcher who had done work both for the Sochi Olympics and also on all of the World Cup sites on migrant worker abuses, and BWI also did inspections. A man named Semyon Simonov, who is the world's expert in migrant labor abuses in Russia and really just wanted to do this work. He was detained on the Volgograd stadium site, and I knew things had changed when we asked, and Andreas agreed, to monitor his trial and his appeal, I think, also as well. But in Volgograd, a really cold, miserable place, Andreas sat in the courtroom. So that's a form of remedy too, because what it meant was that FIFA, by sitting in the courtroom, brought the concern of the sports federation. You never spoke in the courtroom, but you were sitting there as a witness to an injustice. The fact that a human rights monitor was stopped from doing his work. So that's when we knew that things had changed. And I want to say, Andreas talked about the changes at FIFA, but for everyone in the room, this is a lot in 3 years, right? It's putting human rights into your statutes. It's adopting a human rights policy. It's hiring human rights staff. It's setting up a human rights advisory board, an independent human rights advisory board. It's setting up human rights defender and press freedom mechanisms where you can file complaints, where any one of you can file a complaint. So these are all comprehensive, but it's a playbook, really, for what any federation could do. It really doesn't cost that much in terms of money. It costs a lot in mostly time with your family, I'd say, right? WhatsApp messages from me after hours, yeah? Yes. So it's doable, and it produces results that anyone would recognize as remedy. It doesn't always make it right, but it makes it better.
Terrific. The final question, I want you all to be thinking about questions now, because we're going to come to all of you. And I've been given the ability to go a little bit over, I think, right, William? Yes, okay. So we will do that. So Greg, I have 2 questions for you. One was, why did you take this case to CAS? And did you see any other options to taking the case to CAS? And then that's the first question. The second question is do you feel that CAS handled the human rights aspects of the case appropriately?
Thanks, Mary.
To the extent you can talk about it, given the case is under appeal.
Yeah, thanks a lot.
With that caveat.
Okay, thank you very much. I think just coming to the first question, don't forget there's a time span of a decade, 10 years. And that first period, when we represented Castor, we contemplated whether we go to arbitration or not. But given Castor's youth, her age at the time, and so on, we decided, in line with what Castor's instructions were, not to go to CAS itself, because that would attract media attention, may be harmful to her in so many instances. And so we chose a mediated route. Now, coming back to David's comment earlier about finding the appropriate language and the appropriate mindset, we were fortunate enough to have a representative from the IAAF who happened to be African, from Africa. And just that distinction, in terms of a remedy, was so useful in the mediation process, which lasted for 11 months, that we were successful enough to mediate Castor getting back onto the track, and then the rest is history in regard to her successes. As I said earlier, there were other instances which were also not so good, but we were lucky enough to be able to mediate those as well. In regard to the CAS choice of forum, we had no option but to challenge within, because of the linear of the athlete being part of the association, and we had to go to the Court of Arbitration in that regard. We didn't want to challenge in regard to our own national boundaries. That's a bit complicated, it goes a bit further, but that's the line that we saw. You also asked a question about earlier, Mary, if I may just touch upon that, about the biology of Castor and the human rights. You know, the context of, and Mohammed sits here from the South African Human Rights Commission, we have a context, you must see, in terms of South Africa, which given apartheid, where people were told, you're black, you're white, you're colored, you're Indian, you're Asian, constructed by Dr. Verwoerd under the name of apartheid. Now to have a person who says, well, I'm a woman. No, you're not. You're a man, because I tell you you're a man. See, that context and the anger that comes out from Castor is phenomenal. I think that just needs to be said and added in regard to the segregation part and being told. Now, in regard to CAS, could they have gone more in line with human rights? I think they were stopped because of the policy. I think they just haven't got enough weight or wherewithal. And furthermore, I think when we need to look at remedies, are the appointment of human rights arbitrators, people who are schooled, who have what we call the inarticulate premises of arbitrators or of judges who sit there, where they come from, whatever background they may well come from, We need to have inculcated a human rights philosophy, an inculcated viewpoint of human rights, so that when they make their decisions, they are made with human rights in the background.
Just quick follow-up. Did you have any choice in the selection of arbitrators?
Yeah, you have a choice. You do have a choice. And obviously you try and make the choice as best as one can within a limited
The pool that you're given, right?
Yeah, so you're told to go and fish in that pool, and hopefully they're trout, not catfish.
Okay. Well said. So we talked about bringing in the youth voice. Amy, we have a young person. Could you introduce yourself, sir, where you're from, and what is your question?
Hey, my name is Jin-Woo Mo from International Hockey Federation, and I'm also a task force member of UNESCO Sport and Youth. And on behalf of the UNESCO Sport and Youth Task Force, I have a question which came through the Center's Global Online Youth Survey. How can decision makers involved with sport at various levels ensure the safety and security for people who report harm or abuse in sport, as most of them face losing their career or position when they complain against the harm or abuse?
I had a little bit of difficulty. I think it's the echo in the room. So if perhaps, could you rephrase the question, because I want to make sure I get it.
Okay. How can decision makers involved with sport at various levels ensure the safety and security for people who report harm or abuse in sport, as most of them face losing their career or position when they complain against the harm or abuse?
Great question. Okay, so, Yes, so how can leaders in sport, so we're talking about people who report human rights abuses. How can we ensure that there isn't blowback, that there isn't, right? I mean, it's a solid question, because without reporting, there's no remedy, right? One begets the other. And so if there's impunity or there's consequences for reporting, there's no possibility of providing remedy. That was Rachel's first question. Second question, how many of you had something happen and you never reported it? So which one of you would like to take that one on? I'll take Rachel first.
Okay. Thank you. It's an excellent question, and I think it is exactly the question that sport broadly is starting to wrestle with. And I want to acknowledge actually the leadership that the IOC, I think, is showing on this through its own work on prevention of harassment and abuse, looking specifically at the issue of reporting and investigation and follow-up action where this occurs, and in trying to push out that capacity and those systems to all Olympic federations. And I joined a couple of capacity building webinars that they had for other federations recently. What is really tough about this work, though, is that we have existing systems, and they may be for protecting the integrity of the game, they're for match fixing, they're corruption. Again, there can be real risks to people who raise flags about those issues as well. It isn't just in the human rights space. But I think we see the problem that many people do not trust the existing mechanisms. And if we now start saying, let's just open the mechanisms up to new forms of harm when we haven't thought through, maybe we need a step even beforehand. I think there's increasing talk now about the difference between a hotline and a helpline. And what I mean by that is a helpline is something that's a pre-step, right? You don't commit to anything, you just get some advice. What are my options? What are the risks? And you can be assured confidentiality, total confidentiality in that process, while you as a complainant make a decision about how you want to proceed once you know better what the options are, once you have a sense of the risks, once you have a sense of what support you can get. So I think the more we can take the demand that we're seeing from sport to work on this topic, but think in new ways about what kinds of mechanisms we need, that can help address that
that issue?
Thanks very much. It was that's a terrific question, and I wanted to amplify the risks. And we talked about risks as being an essential part. Assessing the risks is the essential part of the UN guiding principles on business and human rights. And athletes are often not in a good position to assess the risks to themselves. And if we take the example I gave earlier of the women and teenage girls of the Afghan women's national football team, the federation president was also a warlord, a former governor of Panjshir province who had his own ability to threaten the women with death. So that's one of the things that you would least expect to find in sport, which is supposed to uphold humanity and human dignity. And I think so you not only have to find out how to complain to prevent other girls and women from suffering your fate, but you have to protect yourself from a credible death threat. Hakeem Al-Arabi faced a similar situation. He was a whistleblower. He told of the torture of athletes. He spoke to the media. So this is something that we will see more of, and I think it means that the federations need the really custom-built systems that protect identities and can bring justice without endangering those who have had enormous courage to come forward.
Okay, Andreas, and then we're going to open to questions. So I see one here, I see two in the back, and I see two right here. Okay, and one over there if we have time. Andreas.
Thank you for this question. It's an excellent one, and one I and my colleagues have been working on quite strongly over the past months, because we've been speaking about this case of Afghanistan. I mean, I think it's fair to say we've been handled the most difficult case possible in any aspect, and in particular also in terms of the aspect of how can we provide for remedy in that context. And at the same time ensure the safety of those who stepped forward in the first place, and also those who had to step forward along the process for us to gather the evidence we needed to be able to have those processes come to conclusion the way we were able to. Now, what can we do? Well, first of all, in terms of confidentiality of reporting, the human rights defenders mechanism is set on a platform that is secure and confidential, and that allows for anonymity of the whistleblower. Protection of anonymity in the investigation, which was a major challenge when we talk about the Afghanistan women case. And then support those who step up, who are witnesses in the case, to be safe. In the case of Afghanistan, it's all public knowledge. So there are many things I cannot talk about on this case, but I can talk about this case. These things for us, it was engaging with the UN and trying to find, is there a safe space in Afghanistan where we can tell these players they can go. And then once things escalated, doing our part in making sure that they can go to a safe environment. And then more long-term, supporting the well-being of them, because it's not something that ends once the president of a federation is convicted, but it's a longer-term process that gets started through such a terrible event.
Okay, terrific. Okay, we're going to take questions. We have one right here. If you could just basically say your name and who the question is directed to.
Can you hear me? Sorry, I'm not sure if I'm... Okay. My question is to Andreas from FIFA. Maybe Rachel will be able to answer as well, since she's part of the advisory council. Related to very much what Greg was talking about, the hyperandrogenism regulations of the IAAF were implemented in 2011, and the IOC had a similar guideline in 2012, where it was clearly said that gender cannot be determined. So kind of withdrawing the idea of gender verification tests and introducing hyperandrogenism as a term. FIFA still has gender verification regulations. What are you planning to do about that?
Thank you. I think it would be too much to say that we have come to terms with that topic. It's an ongoing discussion, in particular around the regulations, but just the broader discussion. How is we as a sports governing body deal with this topic in light of the evolving discussions on it, together with a wide range of other sports governing bodies who face the same challenges. So it's very much something that is being discussed within FIFA and also within the broader sports movement.
Okay, in the back, right back there.
Hello. Yes. Alexander Baranov, Football Union of Russia. I have a really important question. What should we do when we meet situation when athlete meets human rights abuse or racial abuse or ethnic abuse face to face on the field, when there is no evidence, and if he says to everybody that there was case of abuse to him, but there was no evidence after that, that it was just face to face, one by one. What is the decision of such situation?
I'm going to take another, so that's one question. I'm going to take another couple. Let's do Martin in the front and Olawale. And then two over here.
Thanks, Mary. Martin Gibbs. One for you, Andreas, if I may. What would you say to other international federations that are less far along this path and would say, well, we don't have the resources of FIFA, we perhaps don't have the profile, we don't have the infrastructure issues that football does. What would you say to them to encourage them to engage, in these discussions in this room?
It's a great question. Olawale, Ambassador.
Well, thank you very much, Mary, and let me express my appreciation to Rachel, to Minky, but I think I'm going to address this to Greg. I'm so sorry, to Andreas. And Greg, please, wonderful job that you're doing for Castor, and please don't give up. She's not the only one in Africa. You also have another case in Kenya. I haven't said that. I want to direct and it's about the child and football. We're celebrating 30 years of the CRC. I know that FIFA has done a lot in terms of trying to tackle this back from 2014, 2016, as you rightly mentioned. But there is still a lot of trafficking of kids going on in football. And what we found out is that in spite of the changes that FIFA has made, that some of the regulatory frameworks and commercial practices inadvertently, please mark my words, inadvertently yield consequences that operate against the best interest of the child. Isn't it time also that you have Human Rights Watch, you have all this, to also having some good child right experts to work with FIFA to correct these apparent something, and above all, particularly the commercial practices, of whether the intermediaries or the agents, you know the people I'm referring to, and do a lot to reduce the current trafficking of minors from Africa and from South America, mainly to Europe. The second part, Mary, is how come FIFA has not been able to impose some of these great changes you are making on your confederations from other regions? Thank you.
Okay, so that's quite a bit. I'm going to take two more questions. So we have in the back, yes, right back there, yes. If you could ask it real quick.
Yeah, hello. My name is Martin Kainz. I'm from the Vienna Institute for International Dialogue and Cooperation. My question goes to Gregory Nott. Castor Semenya. So yeah, there was the judgment or the decision, however you want to name it, of the CAS. And what are the potential next steps from your point of view? So now you can exhaust the national courts in Switzerland, then potentially the European Court of Human Rights, then maybe treaty bodies. I don't know how openly you can talk about this, but nevertheless, I'm happy if you could share anything on that. And then there was the question of Mary Harvey to Gregory Nott as of the human rights issue in the judgment of the CAS. I think that the term human rights in this decision wasn't mentioned once. So I think CAS is just also missing expertise and experiences with human rights issues. Thank you.
Okay, I think we will chew on that now. So I'm going to go first to Rachel, and then I'll just go right down because I think each one of you had an intervention that you'd like to make. The question. Oh, so the question in the back from the Russian Federation was, what can you just repeat it real quick?
What can we do when athlete meets abuse face to face, when there is no evidence, but he says that it was so?
Okay, so an athlete reports that they've been the receipt of abuse, but there's no evidence to substantiate it. So, who would like to take a response?
Thanks, Mary. I just wanted to start by actually adding to the response to Dr. Mitra's question. I think and I'd simply say that I think it's very significant. There's a much bigger conversation that needs to happen in sport about inclusion rather than exclusion on the basis of gender identity. And I think it's very significant that this is an issue that can now be examined, at least at FIFA, through the lens of FIFA's human rights policy. Right? That's a first. That gives us an opportunity. That's something we can work on. Briefly, Martin, to your question about small federations, this is maybe not what I should be saying, but it's actually extraordinary the amount that Andreas, a single human being, can do. And yes, you have systems in place, increasingly complex systems, and it's not to say that all you need is one person and that's your human rights risk management system, but I think we shouldn't undervalue what a single committed individual, we see this in other sports bodies as well. I'm singling him out because he's up here on the stage. But we see this in other sports bodies too, that a single individual who is committed to this agenda can drive significant change internally on it. And I think that the fundamental lesson of the guiding principles, which is true for business as well, is that you tailor the systems you need to the scale of your operations and to the scale of the risks that you have. And so it doesn't mean that everybody's approach has to be as complicated and multi-layered as FIFA's. It can depend on the nature of the risks.
And the IOC has recently also hired a human rights manager as well, have they not?
Yes, and she's sitting just there. Nelika, do you want to put your hand up? I've just highlighted her for the whole room, so you're going to get a lot of questions at coffee break.
Okay, Minky?
So let me take three of the questions. The question on an athlete, what to do in a case of an athlete. I think for athletes, there are a lot more resources than there once were. And I want to highlight the work of the World Players Trade Union. They've done incredible work to represent athletes as a class on topics like pay equality, but also to represent athletes as having human rights. They were behind an athlete's Charter of Rights. They are our partners in the Sport and Rights Alliance. They've worked on some of these specific cases. There are other organizations that do tremendous work to support athletes. Athletes themselves are a support network. And I do think also an athlete can always bring just like an ordinary human rights defender or an ordinary citizen can bring a complaint to a human rights organization, and we can help investigate it. I wanted to also address the question of what should federations who are at a different place do, and I assume that all federations are at a different place. And a lot of what we've talked about is essentially, it's not cost-free, but the most important thing is a commitment at the top. So the single most important thing is a commitment to human rights at the top, and that actually doesn't have any cost implications. I want to repeat the words of the great John Ruggie. He actually has said in his report for FIFA that all sports federations are enterprises. Therefore, the UN guiding principles apply to you all. Congratulations, you're all waved in. But what really, in order to have a human rights policy and to have it take effect, you really need a decision at the top, and then you eventually will need things like staffing. But I want to tell you that in the interim, there are enormous resources at your disposal. There is the Center for Sport and Human Rights. It's been around for a year, but it's already played this role. And I want to actually refer you to things like the internet. The Human Rights Watch reports on every country and the world, our reports are fully available on the internet. If you're staging an event in Belarus, may I advise you to consult the Human Rights Watch World Report. So there are a lot of resources that are really cost-free, and we're here to help. There was a time when we were seen as the critics. We are the problems because we're bringing these problems to your attention. We actually are here. We want to help. We want to help you develop the policies, and we want to help you work through the problems we identify.
Okay, we have about 2 minutes, maybe 2.5. So let's keep going. Greg.
I have nothing more to add other than to say that Minky isn't that much hated.
Isn't that much hated? Okay. Okay, Jin Suk.
Because we have 2 minutes, and most of the questions were with Andreas, and I want to give a little bit for FIFA, since we've been campaigning on them for a long time. Give him the opportunity to speak.
Thank you.
Friendly. I remember when you two could not be in the same room together,
And nearly
now
missed
you
the red
just gave
card
up
now.
your time to him.
Today I'm not giving him the red card.
Okay.
Well, a couple of very quick points. What to say to a federation? I just agree with what has been said. I think the center is an excellent organization to just have a chat with in a very constructive and open manner, and then see how that sounds in your ears. And as Rachel said, it doesn't have to be an incredibly complex system. It's about understanding the risks and then taking appropriate steps to address those risks. Children in football, I'm happy to take that offline. I just want to say, and that this proves a little bit the point that was made before. A colleague, Catherine in the room, who is our child rights specialist, is working on child safeguarding, but has also been advising the team that has been involved in the revision of the regulations that you were talking about around the protection of minors. So that's very much an ongoing process. FIFPro, I'm sure, can help in giving additional perspectives. And then also there is a conversation happening with a whole range of child rights organizations, including in particular on that topic, UNICEF, to take the best interest of the child into account. I think I stop here.
Okay. All right, terrific. So it's great John Morrison here. Yes, okay. So there are other questions, and we'd love to get to them, but we ran over a little bit because we had a lot of, we were indulged a little bit by the next panel, who's my boss over there, John Morrison, who's been okay with us going over a little bit, but now I must cede the floor back to him. I want to thank our panelists most sincerely for the conversation and for your role. And I want to emphasize again, the Center for Sport and Human Rights is dedicated to providing free, we're a free service. We're in Geneva. We will get on the train and come up to Lausanne or wherever you are, and we will find a way to talk about how do you get started. And I've done this work myself. It was for a mega sporting event, but it starts with commitment, as was said, and then it starts with understanding what your risks are, and then you go from there. So I just want to thank all of you very much, and we will now move over to talk more about collective action.